live in chapter 10 about, what's chapter 10? The decision whether to prosecute, and section 2's selection of the charge. Now moving to United States versus Goodwin, a 1982 case about a challenge that a charging decision was vindictive. Justice Stevens delivered the opinion of the court. Respondent Goodwin was stopped for speeding by a United States Park policeman on the Baltimore-Washington Parkway. Goodwin emerged from his car to talk to the policeman. After a brief discussion, the officer noted a clear plastic bag underneath the armrest next to the driver's seat of Goodwin's car. The officer asked Goodwin to return to his car and to raise the armrest. Respondent did so, but as he raised the armrest, he placed the car into gear and accelerated rapidly. The car struck the officer, knocking him first onto the back of the car and then onto the highway. The policeman returned to his car, but Goodwin eluded him in a high-speed chase. The Equal Protection Clause, okay, this is a footnote. The Equal Protection Clause prohibits selective enforcement based upon the unjustifiable standards such as race, religion, and other arbitrary classification. Respondents does not allege that his prosecution was motivated by improper consideration. Right. So the following day, the officer filed a complaint in the district court charging respondent with several misdemeanor and petty offenses, including assault. Goodwin was arrested and arraigned before a United States magistrate. The magistrate set a date for trial, but respondent fled the jurisdiction. 3 years later, Goodwin was found in custody in Virginia and was returned to Maryland. Upon his return, respondent's case was assigned to an attorney from the Department of Justice who was detailed temporarily to try petty crime and misdemeanor cases before the magistrate. The attorney did not have authority to try felony cases or to seek indictments from the grand jury. Respondent initiated plea negotiations with the prosecutor, but later advised the government that he did not wish to plead guilty and desired a trial by a jury in the district court. The case was transferred to the district court, and responsibility for the prosecution was assumed by the Assistant United States Attorney. Approximately 6 weeks later, after reviewing the case and discussing it with several parties, the prosecutor obtained a 4-count indictment charging respondent with 1 felony count of forcibly assaulting a federal officer and 3 related counts arising from the same indictment. A jury convicted respondent on the felony count and one misdemeanor count. So the respondent moved to set aside, I'm guessing an appeal because the district court's here. There was then a grand jury and then a charge upgrade. And then the facts are above. Was there any question at first? No, not yet. Although the Court of Appeals, respondent moves to set aside the verdict on the ground of prosecutorial vindictiveness, contending that the indictment on the felony charge gave rise to an impermissible appearance of retaliation. The district court denied the motion, so they're still at the district court level. They denied the motion. What kind of motion? Move to set aside. Finding that the prosecutor in this case had adequately dispelled any appearance of retaliatory intent. Although the Court of Appeals readily concluded the prosecutor did not act with actual vindictiveness in seeking a felony indictment, it nevertheless reversed, relying on the decisions in North Carolina versus Pierce, 1969, and Blackledge versus Perry, 1974. The court held that the Due Process Clause of the Fifth Amendment prohibits the government from bringing more serious charges against a defendant after he has invoked his right to jury trial. Unless a prosecutor comes forward with objective evidence to show that the increased charges could not have been brought before the defendant exercised his rights. Because the court believed that the circumstances surrounding the felony indictment gave rise to a genuine risk of retaliation. It adopted a legal presumption designed to spare courts the unseemly task of probing the actual motives of the prosecutor. In North Carolina versus Pierce, the court held that neither the Double Jeopardy Clause nor the Equal Protection Clause prohibit a trial judge from imposing a harsher sentence on retrial after a criminal defendant successfully attacks an initial conviction on appeal. The court stated, however, that it can hardly be doubted that it would be a flagrant violation of the Due Process Clause of the 14th Amendment for a state trial court to follow an announced practice of imposing a heavier sentence upon every reconvicted defendant for the explicit purpose of punishing the defendant for his having succeeded in getting his original conviction set aside. The court continued. The Due Process Clause then requires that vindictiveness against a defendant for having successfully attacked his first conviction may play no part in the sentence he receives after a new trial. And since the fear of such vindictiveness may unconstitutionally deter a defendant's exercise of the right to appeal or collaterally attack his first conviction, due process also requires that the defendant be freed of apprehension of such retaliatory motivation on the part of the sentencing judge. In order to assure the absence of such a motivation, the court concluded, whenever a judge imposes a more severe sentence upon a defendant after a new trial, the reasons for his doing so must affirmatively appear. Those reasons must be based upon objective information concerning identifiable conduct on the part of the defendant occurring after the time of the original sentencing proceeding, and the factual data upon which the increased sentence is based must be made part of the record so that the constitutional legitimacy of the increased sentence may be fully reviewed on appeal. What do they call that? Is that judicial review? And the court applied a presumption of vindictiveness, which may be overcome only by objective information in the record justifying the increased sentence. In Blackledge versus Perry, so that's a rule from common law. Pierce. So we're going to move to the other, not common law, case law. The court confronted the problem of increased punishment upon retrial after appealing in a setting different from that considered in Pierce. Perry was convicted of assault in an inferior court having exclusive jurisdiction for the trial of misdemeanors. The court imposed a 6-month sentence. Under North Carolina law, Perry had an absolute right to trial de novo in the superior court, which possessed felony jurisdiction. After Perry filed his notice of appeal, the prosecutor obtained a felony indictment charging him with assault with a deadly weapon. Perry pleaded guilty to the felony and was sentenced to the term of 5 to 7 years in prison. In reviewing Perry's felony conviction and increased sentence, this court first stated the essence of the holdings in Pierce and the cases that had followed it. The lesson that emerges from Pierce is that the Due Process Clause is not offended by all possibilities of increased punishment on retrial after appeal, but only by those that pose a realistic likelihood of vindictiveness. The court held that opportunities for vindictiveness in a situation before it were such as to impel the conclusion that due process of law requires a rule analogous to that of the Pierce case. It explained the prosecutor clearly has a considerable stake in discouraging convicted misdemeanants from appealing and thus obtaining a trial de novo in superior court, since such an appeal will clearly require increased expenditures resources before the defendant's conviction becomes final and may even result in a formally convicted defendant going free. And if the prosecutor has the means readily at hand to discourage such appeals by upping the ante through a felony indictment whenever a convicted misdemeanant pursues his statutory appellate remedy, the state can ensure that only the most hardy case law holding. The court emphasized that no that the prosecutor had acted in bad faith with malice in seeking the felony indictment. As in Pierce, the court held that the likelihood of vindictiveness justified a permit free defendants of apprehension of such a retaliatory motivation. Here we're going into another case. The court for the first time considered an allegation of vindictiveness that arose at a pre-trial setting. In that case, the court held that the due process clause of the 14th Amendment did not prohibit a prosecutor from carrying out a threat made during plea negotiations to bring additional charges against an accused who refused to plead, with which he was originally charged. The outcome in Borden Kircher was mandated by this court's acceptance of plea negotiation as a legitimate process. In declining to apply a presumption of vindictiveness, the court recognized that additional obtained by a prosecutor could not necessarily be characterized as an impermissible penalty. Since charges brought in an original indictment may be abandoned by the prosecutor in the course of a plea negotiation, and often what is clearly a benefit to the defendant, changes in the charging decision that occur in the context of plea negotiation are an inaccurate measure of improper initial indictment from the prosecutor from which the prosecutor embarks on a course of plea negotiation does not necessarily define the extent of the legitimate interest in prosecution. For just as a prosecutor may forego, the prosecutor may file additional charges if an initial expectation that a defendant would plead guilty to lesser charges proves unfounded. This case, like Borden-Kircher, arises from the pretrial decision to modify the charges against the evidence in this case that could give rise to a claim of actual vindictiveness. The conviction in this case may be reversed only if a presumption of vindictiveness is good reason to be cautious before adopting an inflexible presumption. In the course of preparing a case for trial, the prosecutor may uncover additional information that suggests the basis for finalizing at this stage of the proceedings. The prosecutor's assessment of the proper extent of prosecution may not have crystallized. And when a conviction has been obtained, it is much more likely that the state has discovered and assessed all of the basis of that information, of the extent to which initial trial is completed, is much more likely to be improperly. A defendant before trial is expected to invoke procedural rights and file pretrial motions to suppress evidence, to challenge the sufficiency and form of indictment, to plead access to government files, to be tried by jury is unrealistic, to penalize and to deter the invocatory process in which our criminal justice system operates. Thus, the timing of the prosecutor's vindictiveness is not warranted. A prosecutor should remain free before trial to exercise the process in prosecution. An initial decision should not freeze future conduct. As we made clear in Borden-Kircher, the initial charges filed by a prosecutor may not reflect the extent to which an individual is legitimately subjected to prosecution. The nature of the right asserted by the respondent confirms that a presumption of vindictiveness is not warranted in this case. After initially expressing an interest in plea negotiations, respondent decided not to plead guilty and requested a trial by jury in district court. In doing so, he forced the government to bear the burdens of uncertainty of a trial. The court in Borden-Kircher made clear that the mere fact that a defendant refuses to petition to warrant a presumption that subsequent changes in the charging decision are unjustified. I think that's everything. That's the whole case. This court in Borden-Kircher reached that. So, respondent argues that such a presumption not only requested trial, but he requested a trial by jury. We cannot agree the distinction between a bench trial and a jury trial does not compel a special presumption of prosecutorial vindictiveness whenever the additional charges are brought after a jury is demanded. To be sure, the jury itself may be impaneled. Witnesses and arguments must be prepared more carefully to avoid the danger of mistrial. These matter either a jury or a judge. The state must present its full case against the accused and the defendant's trial de novo at issue in Blackledge. A jury trial, as opposed to a bench trial, does not require final judgment may be obtained. Asked to do over what it thought it already done, has no reason to engage in self-indiction upon against the retrial of a decided question. There is an opportunity to justify an imposition of a prophylactic rule. Abilities of increased punishment, the prosecutor would respond to a defendant's pretrial demand for a jury trial could be explained only as a penalty imposed on the defendant is so unlikely that in declining not foreclose the possibility that a defendant in the appropriate case might prove objectively to the person something that the law plainly allowed him to do. Justice Blackmun concurring in judgment. I find no support in our prior case. The due process clause does not deprive a prosecutor